When filing a divorce in Florida, the biggest document you'll file is the petition for dissolution of marriage. That is the document that opens your case, tells the judge what it is that you want, tells the judge about your kids, and ultimately the relief that you're looking for, whether it's through alimony, through child custody, for child support, or for attorney's fees to be paid on your behalf. If you or your spouse is considering divorce, it is very important to be prepared. You don't want to be blindsided by a process server handing you a stack of 45 pages with only 20 days to respond. I recommend to anyone I talk to that you start gathering bank statements, start gathering financial documents. If you have a joint account, save all the statements. That way your access isn't taken away. If you have access to the school, make sure you have an individual access. For example, if you're sharing an account with your spouse to follow your children's education through the school app, make your own account. Have a separate email. Make sure that you have, you contact your banks, you contact any credit unions, you contact any credit cards, and make sure that your individual cell phone number is set up for two-factor authentication. Otherwise, you may be locked out of your own accounts. The reason why it's so important to be ready for a divorce is because it can happen out of nowhere. I've had many cases where the opposing side will say that, well, I don't have any money. Or my client will come to me saying, oh no, the account just got cleaned out. What do I do? Make the plan first. Don't let yourself become a victim. As far as your children, you should prep by making sure that you have lots of pictures. Start gathering photos of you with your children. That way you have it organized to show the court that you are really the involved parent and not the absent parent that your ex says you are. Again, court is not about the truth. Court is about the truth that you can prove. Make sure you have your proof ready and available before filing for divorce. A question I often receive is, how do I prepare emotionally for a divorce? And I'll tell you, it's not easy. I've been through a divorce myself when I was not a lawyer. I know what it's like. You feel completely powerless. Your entire life is about to change. Where you live may change. How often you see your children may change. Your financial situation may change as you go from two incomes in one house to two incomes in two houses, or one income in one house to living separate, all off of one income. The best way to prepare emotionally for a divorce is just to not be afraid to understand your own feelings. Don't bury your feelings, embrace them. Seek counseling. People are there to help. Also, start planning ahead to make that intermediate period between when the case is filed and when you actually get divorced, which can be up to a year. Be ready for that time. Look at your own living situation. Will I remain in the home? Do we have enough room for us, me and my spouse to live in separate bedrooms? Is either one of us going to move out? What if I move out? Will I be able to see my kids? I always tell clients, and remember this, I always tell them this. No matter what you take away from what I tell you today, remember one thing. Do not move out. Do not move out. Do not move out. If you do, you're setting yourself up for a situation where you could be paying for two households at the same time. If you do, you're setting yourself up for a situation to pay child support. If you do, you're setting yourself up for a situation where you have to ask your ex permission to see your own children. That is nuts. Don't do it. Don't move out. Don't panic. Don't take any rash actions. If you're the spouse who makes significantly less money than your ex, be very careful what you do. If you were to move out and get a small studio apartment, you won't have room for your kids. But worse, you've also lowered your monthly expenses. Alimony will be determined based on your need and your ex's ability to pay. If you move into affordable housing and have no need, it doesn't matter how much your ex makes. You're not getting any of it. So please, whatever you do, talk to a lawyer first. A lot of people ask, what steps should I take right before filing or after filing for divorce? And this is an area where you really need to be careful and you really need to know your spouse. For example, what do I do with the money? Do I leave it in a joint account? Do I still have my paycheck go to a joint account? And that really depends on the dynamic between you and your spouse. In most cases, I tell my clients to take 50%, not all, but one half of the money in a joint account and move it to a personal account, and then to not spend it. Again, you are protecting an asset. You are not draining the account. If you drain the account, It's another one of those short-term gain but long-term pain. The court will not look favorably upon that. So again, in most cases, make sure your two-factor authentications are set up to your individual cell number. Make sure that that cell number is under your control. Make sure that any joint accounts or any joint credit cards or any accounts where the other side's an authorized user, make sure that they're set up to be ready for a separation. And most importantly, call and ask a lawyer. A lot of people ask, have I lived long enough in Florida to file for divorce? And the answer is, it depends. Florida law requires that you and your children, or you or your children, have resided in Florida for at least 6 months prior to filing for divorce. How do you prove it? The most common way to prove how long you've been a resident of Florida is through your Florida driver's license. So long as your Florida driver's license has an issue date that is 6 months or more prior to the filing date, Florida has jurisdiction. But what if I don't have a current Florida driver's license, or I just haven't changed it yet? Or what if I waited 3 months and my Florida driver's license does not have the right date? You're okay. We can do an affidavit from someone that knew you were here, usually a landlord if it's an apartment, or a neighbor if you live in a community. An affidavit, it's a sworn written statement from someone that can testify under oath that you have been a resident of Florida for more than 6 months. For children issues, the children must have been residents of Florida for more than 6 months. So you might say, well, hold on. I moved here, but my ex and my kids are in Georgia. Where do I file for divorce? And again, it depends. You can file for divorce in Florida because you have been here for 6 months. But Florida does not have jurisdiction to do anything beyond granting you that divorce. Your kids that are still in Georgia, that must be litigated in Georgia. If you have doubts about jurisdiction, because again, I get it, it's complicated, call a lawyer. They'll tell you the answer. If you have any questions about the process before a divorce, call us or go to our website, tampadivorce.com. There's a lot of helpful information there. And again, please feel free to call. We are here for you.